Good afternoon, everyone. I'd like to give a warm Wake Forest and Journal of Business Intellectual Property Law welcome to Brad Watts, who is going to be our guest this afternoon in our conversation about IP policy and the pandemic. I'll just give you a brief introduction on Mr. Watts, but a lot of what he does will be incorporated into our discussion. So, just as a brief introduction, Brad is currently serving as the Minority Chief Counsel for the Ranking Member Tom Tillis on the United States Committee of the Judiciary's Subcommittee on Intellectual Property. So he's going to tell us a lot about what he's responsible for, but just to give you a little preview, last year, on the last session, Brad was the chief counsel and the staff director for the 117th Congress with respect to the subcommittee on intellectual property. And he led the charge in the midst of a pandemic. We still passed three important pieces of legislation: the CASE Act, the Trademark Modernization Act, and the Protecting Lawful Trademark Act, all landmark bills. So while we have the topic of IP policy in the midst of a pandemic, I think our discussion is really going to go more towards how bipartisanship support and the strength of having a bipartisanship subcommittee allowed these bills to ultimately pass and thrive. And there are certain pivots I'm sure we will discuss had to be made in the midst of the COVID-19 pandemic. So, Brad, I'd love for you to tell us a little bit more about yourself and how you got from Roll Tide, University of Alabama, to your current position with the IP subcommittee.
Yeah, thank you, Professor Rose, and again, thank you to all of you and to the Journal for having me here today. I'm very glad to be able to participate, and thank you for the very lovely introduction. It is the most beautiful obituary for a living person I think I've ever heard. So, a bit about my background. As you indicated, Professor, I'm a native Alabamian. I grew up in Alabama, went to the university for law school. And I came to Capitol Hill straight out of law school. And what I often tell people is Congress is still very much like a medieval craftsman's guild in the sense that there is an expectation that you will kind of intern, clerk, and work your way up through the ranks. And my career path is really no exception to that. So when I was an undergraduate student, I interned for my then home state senator. I then clerked for his subcommittee staff in law school. He was on the Judiciary Committee. When I graduated law school, he had an opening in his judiciary staff, and he hired me for that. And he very much hired me because he had worked with me before. He knew my work product. His staff knew my work product. And so I started with him and have been on Capitol Hill ever since, held a number of positions on Senate Judiciary Committee, handling a variety of issues. And so, my encouragement to anyone who's thinking about a career on Capitol Hill, particularly, but in any government branch really or agency, is to come up, do internships, do clerkships, build a network. There was a survey a few years ago that found that something like 96% of all Capitol Hill jobs are never posted publicly. It's all through word of mouth or a network. Again, very much like a medieval guild. So for those interested, take advantage of those opportunities and please feel free to use me as a resource.
Oh, I'm sure our students will be motivated and will take advantage. So could you tell us a little more about sort of the structure of the Judiciary Committee on Intellectual Property, its purpose, and how the normal work process flows within the committee?
Yeah, so the Senate Judiciary Intellectual Property Subcommittee is actually relatively new. So it was reinstituted in 2019 at the request of Senator Tillis, who I work for. We had not had a dedicated intellectual property subcommittee on the Senate side, at least since 2006. Now, we do have a dedicated subcommittee on the House side that has been a regular standing committee, but on the Senate side, for whatever reason, we had not had a subcommittee in 12 years. But Senator Tillis led the charge to have the committee reinstituted. And I can say without a doubt, at least last Congress, it was probably the most productive and most bipartisan subcommittee in Senate Judiciary. We held something like, I want to say 19 hearings, multiple staff briefings, produced an ungodly amount of work product. I'm shocked I haven't got more gray hairs because of it. This Congress, the subcommittee is going to be chaired by Senator Leahy, who is a good friend of Senator Tillis. They work very well together. I work very well with his staff. They are not only colleagues, but friends. So we're very excited about that partnership, even though obviously we would love to still be the chairman. But, if we have to give up the gavel, at least we're giving it up to someone like Mr. Leahy, who is a good partner. But, I would say the key thing for everyone to realize about intellectual property is it is one of the few areas left in Congress that is not partisan. And what I mean by that is people obviously disagree. They have different viewpoints on intellectual property, but it's very much driven by academics, by region, by how people think about the issue. It's not driven by, partisanship, meaning there's no Democratic or Republican talking point. Senator Tillis cooperates very closely with some of his Democratic colleagues on intellectual property, and he disagrees respectfully with many of his Republican colleagues. It is not an issue that really is defined by party line, which for me as a lawyer, and my advice for anyone thinking of coming to work on these issues from a policy perspective is that's actually a very good thing. As lawyers, we're trained, right, to think analytically, to make the best argument, to check and to recheck our thought process. And you still very much can do that with intellectual property issues. And so that is probably the most rewarding aspect of the job.
I agree. I was telling the students a little bit earlier about the 1976 copyright, because I want to ask you about the Case Act in a second. That when that statute was drafted, the House and Senate subcommittees actually went to all of the stakeholders and instructed them, you guys need to get together, sit at the table, draft the statute, and then come back to us. So it was interesting how, just at the onset, they realized, well, there's going to be a concerted group of people. They may not all agree, like you said, but they all have the same vested interests to bring copyright law into the 21st century, ultimately, the 20th century then. But I think that it might be interesting for us to take a walk through something, for example, like the Case Act. How did you start? What was the process of getting to the point where this bill ultimately passes?
Yeah, so I'm actually going to take that question and spin it a bit. Not that the Case Act isn't important, but Senator Tillis was one of the lead Republican sponsors on it. But that was primarily Senator Kennedy's bill. So I don't want to take any credit or thunder away from him. But I will talk about the Protecting Lawful Streaming Act, which you referenced. That was Senator Tillis's and Senator Leahy's bill. And that was, one of our babies last Congress. And the process we used to get that enacted into law is very much the process you're talking about. And so for those who aren't familiar, prior to last December, the illegal streaming of copyrighted material was not a felony. Everyone, I'm sure, is familiar from their days as kids watching movies where you have the FBI warning that, the reproduction of this movie, if you make a VHS copy, is a felony. That is a throwback to the 76 Copyright Act and beyond, dealing with what was at the time the primary form of copyright piracy, where people were literally, think about going into movie theaters, videotaping the movie, bootlegging copies, and selling them. Unfortunately, again, until at least last December, copyright law had not kept pace with the times. As everyone knows now, streaming is the primary form in which Americans consume copyrighted materials, from music to movies to television. But under existing law at the time, the illegal streaming of copyrighted material was only a misdemeanor. Now, the first thing probably everyone thinks of when I'm talking about this is, oh my God, why would we want to make streaming a felony? Everyone streams. Are you really telling me that if somebody accidentally goes to a website and illegally streams a movie that we want to put them in jail? And the answer is no, of course not. The problem is, over the last decade, we've seen a rise in what's known as commercial piracy websites, particularly in the area of live sports. So think about a UFC fight, for example. I like UFC. You may have to pay 100, 150, dollars for a pay-per-view to watch the whole fight. But these commercial piracy sites, what they do is they will pay for that one pay-per-view, and then they will broadcast and stream it to their network. And what they'll say is, pay us a one-time fee of $5, and you can stream this fight illegally. The issue, as you can all imagine, is the cost to the economy, and it's not just live sports; it's movies, it's music, it's everything we stream digitally. The cost to the economy is massive. You're talking about billions, $26+ billion every year lost to copyright piracy. So the issue we were trying to fix is, how do we craft a targeted law that allows for the felony prosecution of those commercial piracy sites? So the people who are operating at scale and really trying to make money off of stealing someone else's intellectual property, but not allow for the prosecution of, for example, my grandmother, who may inadvertently go to a website that has illegal copyrighted material not knowing, or for people on YouTube, for example, who are using snippets of songs or snippets of movies to make an educational video. Those are people that no one wants to see prosecuted. So what Senator Tillis and Senator Leahy did is they brought all the interested stakeholders to the table in January of 2019 and said, look, this is a problem. The commercial pirating of copyrighted material is a problem, but we need to find a solution that allows DOJ to pursue those people, the true bad actors, but protects all the good guys, the individual streamers, businesses who are in licensing negotiations, people who may be posting YouTube videos. And what we did all throughout 2019, both in person and virtually once the pandemic began, is we held stakeholder meeting after stakeholder meeting to continue to narrow and refine the issues. And what ultimately resulted was the Protecting Lawful Streaming Act, which is a true consensus product. No one was opposed to it. And the reason is because it was narrowly targeted. It only allowed the government to pursue prosecutions against a very narrow class of people with criminal intent who were making large sums of money, and it protected the general public. And that model is something I think, again, that is unique about IP because it is academic, it is thoughtful, it is bipartisan, and you can truly have a consensus-driven process. And so we're very proud of the work we did there. We're very proud that bill was enacted into law, and we are most proud of the fact that all the copyright stakeholders who had an equity were heard and participated in the process.
Wonderful. So here's my question on that spin. How did you manage in the midst of a pandemic to get it across the line and actually signed by the end of December?
Yeah, I mean, so I think like everyone, and this isn't unique to government or to Congress or anyone else. I mean, I think when the pandemic began, right, having to figure out how to do our work virtually was a challenge. I mean, we're still having issues with Zoom, right? I mean, I don't go through one Zoom call where I don't have a technical issue. It's just, I think, the nature of it. But, once we figured that out, once we realized, we were going to have to transition to a totally virtual format, it was pretty easy. Instead of meeting in person every 2 weeks, we met via Zoom. Now, granted, there are some logistics to that. I mean, having to facilitate who speaks, who talks, but like any group having to deal with Zoom or virtual meetings, you figure out how to make it work. But I would say, if anything, the pandemic not only didn't slow us down, but having to go to a virtual format actually helped us to speed up things because, instead of people having to fly in from different parts of the country and having to find a meeting time that worked based on, people having to fly from Los Angeles, for example, we could pick meeting times more easily because people were just Zooming in. So once we got that down, it was actually much easier to make progress. And I actually think part of the reason why we were able to get that done was because of the pandemic. And I don't say that to make light of the pandemic or to say I'm glad the pandemic happened. Please don't take it that way. But I think the pandemic actually highlighted how dependent we are on legal streaming. But it was also a time when these commercial piracy sites were getting massive profits because as streaming went up, illegal streaming also went up. And so I think part of why we were able to get this enacted into law is because there was a recognition that, we're in a situation where people who are dependent on their music or their movies or their creative property rights, they're no longer getting revenue sources from live performances or from live shows or from people going to movie theaters. So, we have to find a way to protect against this kind of commercial copyright piracy.
Indeed. We want Spotify and iTunes and all of the legitimate streaming platforms to continue to be able to offer us such a rich array of content.
And,
So
and
during,
and on that
uh-huh,
point, I'll just note, that was one of the great things about that process is, all the interested stakeholders were at the table. You had the legitimate streaming platforms. You had the internet service providers who were worried about intermediate liability. You had
mhm.
advocates of the public who were worried about potentially over criminalization. And because all of those voices were there participating in good faith and were heard, we ended up with a product, that got the job done and didn't hurt anyone but the intended target, the commercial pirates. And so I truly hope it is a model we can replicate in the future.
Yes, 10 years imprisonment and fines should be a pretty effective deterrent, I would think. During the pandemic, has the subcommittee had to deal with any other IP issues, either in the field of patent, copyright, or trademark, that weren't addressed by these three key bills that were passed?
Yeah, I mean, it's a very good question. Did we address anything in terms of a bill? No, but are there issues that are, I think, percolating because of the pandemic? Yes. And I think the obvious one is the nexus between intellectual property, i.e., patent rights, the development of vaccines, and access to vaccines. And there's a lot of differing opinions about that. But, you know, at least for Senator Tillis, at a fundamental level, our belief is part of the reason why private industry was able to so quickly mobilize and develop a vaccine is because of the rigorous intellectual property system we have. And now, granted, obviously, if you develop a vaccine, you want people to have access to it. You want it to be affordable, which is why you saw the government step in and provide the resources to make the vaccine for free. But there's a lot of debate going around about the nexus between those things. You have some people who think, the companies that develop this vaccine shouldn't be able to receive intellectual property protections for it. Or at the World Trade Organization, for example, you have some proposal to waive the TRIP protections related to patent rights for vaccines. Our position, and I mean ours and Senator Tillis, is that is the wrong approach. Absolutely, we need to make the vaccines accessible and affordable, and the government is doing that by purchasing doses and making sure Americans have access to it for free. But breaking the patent system or weakening intellectual property rights around the development of the vaccine, we think is actually the wrong incentive. We've shown that the intellectual property system can work. The patent system has shown that it can rise to the challenge and provide those life-saving and innovative cures and treatments. And we need to ensure that we continue those protections so that when the next pandemic hits, we're prepared. And I would say the other issue for Tom, is the pandemic has also really heightened the issue of the need for patent eligibility reform. For all those who are in the patent space, it's probably no shock. That Senator Tillis has long said patent eligibility reform needs to be a top priority. But I think the pandemic has actually highlighted even now more than ever why it needs to remain a priority. We want our innovative companies to be developing new life-saving cures and treatments. And when you have whole areas, whole fields that are patent ineligible by virtue of some of these judicial exceptions, you really are inhibiting that next generation research and development that's going to prevent us from going through another, quote, once-in-a-lifetime pandemic.
Okay, I'm going to pack a couple of those things.
There's a lot going on there.
It is a lot going on there. On the first issue, because I've written some pieces about access, and I probably am a little more progressive in my views, but I do agree with a lot of what you're saying, just about everything you're saying about whatever you do, you've got to preserve the incentive to continue to create. So I definitely applaud the fact that these companies are able to create these vaccines. My concern is, we're only, like say in North Carolina, we're in phase 3, for example. And in many states, even within phase 3, for Florida, people over 65 are having trouble getting physical vaccine. So I applaud when the market works the way J&J and Merck did, and with Merck stepping up and saying, okay, we'll help you manufacture, give us access to the information, we'll help you manufacture the drug. In theory, we would hope the market continues to work like that in the future, but has Congress considered, because we know the TRIPS provisions do provide that if you're in this emergency access situation, that you can go off patent and have third parties produce if it can be done within the country. And so there's lots of controversy about how that plays out. So without changing TRIPS, in theory, there would be some ability to increase physical access, but I'm curious, what's your view on, do you think the market will continue to operate like it is now with Merck stepping up, and maybe other companies will step up and partnerships will be formed? Or do you think we might end up having to look at some legislation with respect to physical access?
Yeah, so that's a very good question. And I'm not, I have a few points I'll make, but I can't do more than that, mostly because a lot of that is getting into issues of production and kind of healthcare access and equities, and those aren't issues I handle, and so I don't want to overstep my bounds and speak. But I would just say generally for Senator Tillis, his philosophy is, yes, we have to ensure access. The issue we're seeing now with vaccines probably generally is an issue of production and supply that isn't necessarily driven by the exclusivity of the patent system. That I would say would probably generally surmise his position. But past that, I can't say much because, again, it's not my issue area. All I would point out, and this is a personal observation for me, not on behalf of my office, is you have a warehouse, I think, in Ohio that has how many million supplies of the vaccine that are just sitting there that aren't being distributed. That, to me, is a function of distribution and production and supply chain mechanisms, not that there's a lack of access because of a patent potentially blocking it. But yeah, again, sorry not to dodge, but I want to make sure I don't get fired.
No, perfect. I was not trying to create a partisan divide. I was just raising, something that Congress could, because with our population. So at some point, you're right. Production is sitting in some places, and some places production's not there at all. So I was just sort of trying to use a crystal ball to see if the subcommittee would think about, if production does become an issue, what might happen. But no, I think it's perfectly fine to point out everything that we're discussing. With respect to different constituencies that could be affected by the variety of IP issues that the committee raises, who do you find really steps up to the plate and comes forward and says, look, we're having this problem, like the illegal streaming, and we know who would come to the plate first. But with other problems, like, for example, the Trademark Modernization Act, where people are saying you're warehousing all these trademarks and you're registering them, but they're not necessarily being used, or the person who got the, elevated from intent to use to actual use didn't really present accurate evidence of the scope of their actual use. So how what kind of constituencies are you seeing in these other spaces coming to you and saying, look, we're being affected, what can you do?
Yeah, so I'm very lucky in the sense that Tom has always been a big believer, and he actually promotes a policy of kind of open access for our office, pun intended. We will pretty much take a meeting with anyone to discuss an issue, even if they are not constituents. We're a firm believer that if we have the privilege of being in a subcommittee leadership position, obviously we look out for our constituents. You're our first priority, but it's a national platform, and we need to have an open door to hear from stakeholders across the country. I will tell you, usually the best advocates are the ones who come with a logical argument backed up by facts. So many people, not just on IP issues, but any issue, come in with kind of pre-prepared talking points that aren't dynamic, that aren't reflective of the audience you're talking to, that don't present an opportunity to actually have a dialogue. The best advocates are ones who don't do that. They come in, they know the facts, know the law, they know the issue, and they're prepared to have an honest dialogue. And part of that dialogue may be themselves reassessing their own position. Those are the effective advocates. And I know for me, when I'm looking for an issue to present to the senator, something that I think is worthy of his time, I'm listening for those fact-based arguments. I'm looking for advocates who are going to tell me something is a problem, give me the facts. I'm going to ask them questions and push them. That's my job as the senator's lawyer. And if they come back to me and can rebut presumptions I may have, if they can show me that I'm wrong or affirm that I was right to think that the issue they raised was meritorious, that's when I'm going to take it to the senator. But again, having a national kind of platform by virtue of having a subcommittee, our philosophy is we need to be open to hearing from all stakeholders, to listening, and to really learning. And again, that's the great thing about IP, right? Is if someone comes in to talk about an intellectual property issue, it's probably going to be really wonky and candidly, and I say this as a nerd myself, really nerdy. It's going to be a fact-driven discussion as opposed to, unfortunately, more partisan aspects of the things that Congress works on. And so, generally, I would just say for those who want to be advocates, for those who want to work in this space, being willing to listen, to learn, to acknowledge when you're wrong, and to check your own factual assumptions. And that's usually going to lead you, if you do all of those things, to something that is a meritorious project.
So are you the first stop in the process? So if I represent a constituency that has some proposed changes to the Lanham Act, the Trademark Act, do I contact the council's office first, or do I go to Senator Tillis's office in North Carolina and try to make a plea to connect to you?
So you can really do either. So, I'm an open book. You guys have my email, and for anyone who reaches out to you and wants, you can share it. There's no kind of uniform process. We'll have some people, both national stakeholders and constituents, who will reach out to a local office for Senator Tillis, and they'll connect you with them. We'll have some people who reach out directly to me. And usually when someone reaches out, like I said, we will do a meeting with anyone who wants to. We will listen, we will learn, we will observe. The senator tries to make as many meetings as he can. As you can imagine, though, his time is more valuable than mine. Just by virtue of volume, the number of meetings he can do is much less in this portfolio, just because he has several other committees he's also balancing. But yeah, usually people will meet with me, they'll chat with me or a member who on my team. We'll assess, we'll analyze, and we'll usually try to get back to you and say, well, we don't think this issue is something that Senator Tillis is going to have time to focus on, or we don't agree with you and here's why, or we actually agree with you, this seems like a great issue, can you give us some more information? So yes, there are multiple ways to get in touch with us, there are multiple ways to engage with us. The key thing is just making sure you're engaging in a thoughtful and meaningful way. That is the best path to success.
Well, that is definitely good to hear. So has the pandemic, because you spoke a little bit earlier about, wow, now that we're Zooming, it's easier to have meetings, it's easier to bring people together. Has the pandemic slowed the constituents trying to seek access, or is everything about the same? Have you noticed in the past year or so?
Yeah, it's a good question. And I would say there's been good and bads, right? So on the good side, I would say it's actually probably allowed us to reach more constituents because, again, just by virtue of being remote, you have more times, more options. So think about pre-pandemic. For those of you who have been to DC, maybe you've been there as part of a lobbying day or an advocacy day for an organization. Your organization may only be there for 2 days and you have very tight timetables and schedules to meet. And, everyone tries to make as many meetings work as they can, but sometimes that's just not possible. Versus doing things remotely and virtually, it frees up, the possibilities for meetings. So I would say we actually are more accessible than we were pre-pandemic, not because we weren't trying to meet with as many people, but because we have more options and flexibility. Now, that said, I do miss the in-person meetings. It is always great to see people in person, particularly people you work with regularly, but also for constituents. Like I'm thinking of the number of North Carolinians who would come up to DC for advocacy or lobbying or to talk about a personal issue, and they would turn it into a trip, right? This may be their first time to be in the Capitol or their first time to be in DC for 20 years, and they do with their families or their kids. And so they're not just there to meet with our office, they're there to, also experience and see the beauty of, the American capital city. And so I do miss that aspect because there is something fun about, being able to end a meeting with a constituent, having half an hour on your schedule and saying, hey, I know you wanted to do a Capitol tour. Do you want me to give you a Capitol tour? I'd love to walk around the Capitol and show you some of the sites. That is one thing I really miss because independent of anything professionally, that is rewarding and fun.
Okay, so I'm gonna hold off on my visit until I can get a tour.
When you want to come up, you let me know. Shoot me an email. We'll not only get you a tour, but we'll do a full day of sites for you and grab some lunch, and we'll talk IP policy.
Sounds like a plan. So you mentioned earlier about, subject matter eligibility and Mayo versus Prometheus and the Marriott case and the CLS case. The Supreme Court may be stifling some of that. I want to sort of go a level above that because I noticed that Senator Tillis initially introduces the Strong Act. And then later the House comes up with the Stronger Patent Act.
So that actually is a bill by Senator Coons. Senator Tillis
Right.
has never co-sponsored
Okay.
the Stronger bill. There's a lot in there he agrees with, but there are two areas he has concerns with respectfully and disagrees with his colleague, Mr. Coons, on, those being the presumption in favor of injunctions and the one bite at the apple approach to inter partes review.
But the Stronger Act was introduced in the last session, but it didn't pass anyway. So
correct. It was introduced, I believe, by Senator Coons, Hirono, Kennedy, and I want to say Mr. Cotton may have been the other on it. But yes, Senator Tillis has never co-sponsored that, despite there being many things he does agree with.
So where are we today? So that's what I want to get to. So the pandemic sort of pushed all that, the patent developments aside. And I can kind of see that because you had such major developments that grew out of the Leahy Patent Reform Act and what we have now with the first to file. But the proponents of the Strong and the Stronger Act argue that, there are all these things about the last Reform Act that needed to be fixed, or they were unintended consequences that resulted from the act that we have today, or the patent statute that we have today. So where do we stand now? Is Senator Tillis, I know you raised that patent subject matter eligibility is something that's huge. So what's going on to bring all of that back to the table? Anything?
Yeah, so it's a good question. I mean, I would fully expect Senator Coons is going to reintroduce the Stronger Patents Act to this Congress. And again, many of the underlying issues motivating that bill, even though we're not a co-sponsor of it, Senator Tillis does agree with. Look, the Senator is a firm believer in the PTAB and the inter partes review process. It is valuable in weeding out low-quality patents. There's no denying that. That said, it also was meant to be an equitable forum. It was not meant to be a death squad. It was not meant to be a place where patents were presumed to go to die. It was also not meant to be a place where larger companies could basically bully small or medium-sized entities or independent inventors into submission. And we have seen some of that gamesmanship over time. Now, that said, I do think some of the administrative reforms made by Director Iancu helped correct those problems. I'm thinking of harmonization of the claim construction standard. I'm thinking about the general plastic and valve factors, which dealt with the issue of serial petitions. Senator Tillis was is very supportive of those reforms and would like to see some of them codified. In terms of, the prospect of any legislative action on the PTAB front, I think a lot of that is going to depend on what the Supreme Court does in the Arthrex case. For those who aren't familiar, the issue in Arthrex is dealing with the constitutionality of the appointment of PTAB judges. If SCOTUS, I think, rules that those judges are unconstitutionally appointed and that the issue of their appointment is not severable from the statute, i.e. the PTAB is null and void, I think you're going to see Congress move very quickly to not only correct that problem, but potentially address some of these kind of secondary issues related to the equitable fairness of the forum. So no, I mean, Senator Tillis doesn't support going to an approach to PTAB where you only get one bite at the apple, where PTAB isn't accessible or available. He just wants it to be a fair forum for all parties, and that includes big companies, but that's also small and medium-sized entities and independent inventors.
Right. I mean, even before this current version of the Patent Act came about, there was gamesmanship that was used, leveraged with the reexamination process. So this is something that has been an ongoing battle since I entered this space 26 years ago. I think the inter partes um, statute provisions that came in under the most recent view of the act maybe led to more of that gamesmanship. But I'm glad to hear that the senator is still looking at it from a fair and balanced approach. It was
Yeah, and
interesting.
I
Mhm.
think you raise a good point too, or you hinted a good point too, which is, it's important to remember. I'm a firm believer, that when people act and try to legislate, they're truly trying to do their best to address an issue, but you can't foresee every possible consequence of something you do, right? And we all know this as lawyers, right? We're always trying to find ingenious new ways to benefit our client, and so I don't think the PTAB was designed to be an unfair forum, and I don't think it is largely an unfair forum. I just think, just like with anything, over a number of years, some actors have figured out how to game that forum in an unequitable or inequitable way. And that looking at the PTAB now 10 years out from the America Invents Act, it's an opportunity to maybe course correct on some of the truly egregious behavior, but keep the fundamental forum that is meant to weed out low quality patents that shouldn't have been issued based on prior art issues um, operating. And so that's kind of the mindset I think Senator Tillis looks at it. It's not that the PTAB is evil. It's not that the PTAB doesn't have a valuable function. It's that just like any other institution of government, over time you see cracks and fault lines that you have to patch up.
Agreed. Is the senator or the subcommittee involved at all with the development of greater access to biosimilars and these issues going on with, can we get this purple book out here where these patents can be fully disclosed? Is any activity going on in that space? I have a personal interest in that area.
Yeah, there is, but unfortunately, that is actually handled by two separate committees, the Committee on Finance and the Health Committee. So it's interesting the way the Senate divides up jurisdiction. Issues related to intellectual property upon their issuance, particularly on the patent side, are in Judiciary's portfolio. But
Okay.
things related, for example, to kind of the distribution or supply channels, you know, uh, FDA type issues are handled by separate committees. And so while there are things going on, it doesn't fall within our portfolio, even though they are intricately related and interrelated. But no, that thankfully, I think I don't have to deal with FDA issues. That's a whole nother complex area that I'm glad I don't have to wade into.
Yeah, but the US is a little bit behind the ball with respect to biosimilars. It seems like, a lot of our sister treaty nations have found a way to get them out there and to have sort of a fair balance between protecting the innovators and the original producers of the biologics against, this realm of people that are going to introduce something that is not a bioidentical, but is maybe
Right. And it is a hot
effective.
button. It is a hot button issue. I mean, I think the Senate just last week passed a biosimilar bill. Now, it's a bill that basically requires the FDA to put out regulatory material that encourages doctors to push their patients, well, not push their patients, but to make their patients aware of biosimilar options and to encourage that. So it doesn't solve the problem you're raising, but in terms of being a low hanging fruit, in terms of I think
Yes.
signaling where the Senate is a whole thinking about these issues, yes, biosimilars are very much on our minds, both domestically and in the international context. It's just unfortunately, at least from the FDA side, not something I have my hands in.
Yeah. Now, I must applaud the FDA. The Biosimilar Action Plan was most certainly a step in the right direction. It's unfortunate that as an agency, they can't control all of the things they want to control. So I think you're right. The low hanging fruit is a great place to start, and we will just keep growing from there.
And that's something. I mean, you're really hitting on a point I was going to make later, but I'll make it now, which is, you know, especially in the world of intellectual property, you almost never see these things in the news, right? They're not what drive headlines, but there are so many low hanging fruits, not only within IP, but every policy area that Congress is constantly addressing. You know, despite what may be portrayed in the media, Congress actually passes a lot of bills every single year unanimously, because they are issues of, you know, low-hanging fruits that are truly good governance bills that, you know, they may not fully address or resolve a problem, but they take a step in the right direction and marginal progress is made. And so, you know, just for those who maybe have a negative perception of Congress, you know, just remember probably 90% of what we do isn't seen or heard about, but it is good work that you know truly helps people.
And I think that is very good information to share with our students because the media does portray a different picture. Last question about legislation, and that is the Digital Millennium Copyright Act. I know you're working on some amendments in the prior sessions. What's going on now?
Yeah, so Senator Tillis, you know, his approach to intellectual property issues is he said from the beginning when he became chair of the subcommittee, I want to be thoughtful. I don't want to just hold a hearing and have an echo chamber where people tell me what I want to hear. When I try to legislate on something, I want to hear from all the interested parties. I want to think about it, be responsive, and we may still disagree, but I want to be able to disagree because I have all the facts, I've heard their argument, and I have reached a different conclusion, not because I want an echo chamber that's going to validate my own viewpoint. So last year, all throughout 2020, we held a year-long series of hearings on the Digital Millennium Copyright Act. We covered everything from the DMCA's origins to how foreign jurisdictions are handling copyright law to the nitty-gritty of things like Section 1201 and the right to repair. Based on that year-long series of hearings, we released a discussion draft in December. And I use the word discussion draft for a reason. Senator Tillis is also a big believer of, especially on some of these bigger things, not just plopping a bill down and trying to get it passed. That's not thoughtful leadership. He wants to have the public engage with him and give him feedback. And so he released this discussion draft in December, and he told stakeholders, by March, you have until March 5th, but we want you to go through this. Tell us what you like, what you don't like, what your concerns are, what you think some of the unintended consequences may be. Are there things that are in here that shouldn't be? Are there things that should be in here that aren't? And so we just, at the end of, I guess, 2 weeks ago now, received that feedback. So what we're going to do is we're going to spend about the next month and a half going through that feedback line by line, thinking about it, comparing our notes, looking at the draft, and make revisions. And then we'll actually introduce a bill once we've done that. But even once we introduce a bill, Senator Tillis has been very clear, this is a multi-year, multi-Congress project. Something as complex as digital copyright law can't be fixed by just dropping a bill and trying to pass it. So even once we introduce the bill, he's been clear what he wants to do is replicate the process that was successfully used during the felony streaming negotiations by bringing all the interested stakeholders to the table, giving them a voice, a chance to be heard, having them negotiate, so that we can find, you know, a narrow possible path forward to fix some very real issues. You know, it's not just issues of copyright piracy in the DMCA. We also have issues related to the right to repair. You know, we have issues of access. You know, we have orphan works issues. You know, there are a whole host of issues that aren't just related to a quote unquote notice and take down or notice and stay down system, even though that probably is what captures most people's attention. So we're looking forward to getting that bill introduced on a bipartisan basis and to having a really thoughtful, you know, probably multi-year long series of negotiations to try to get, you know, a product.
That's what I've always admired about decisions and bills related to the DMCA, even way back in the day. For all the students, it's kind of, the DMCA is broken up into two parts. One part deals with shielding internet service providers from liability. So that's the takedown notices and how fair use plays into that and how responses are made and the duties of the Verizons of the world to disclose IP addresses and the like. And then 1201 deals with this concept of putting digital locks or encryptions on protected material. And it's always been controversial, and we've always had exceptions, exemptions that have been put in and taken out and tweaked. But what's beautiful about that process, which is why I love to hear Senator Tillis's platform, is that there's always been an opportunity for commentary, for public commentary and hearings and differing viewpoints to be brought to the table.
Yeah, and we tried really hard to make sure we had in our year-long series of hearings that we were not only thoughtful but heard from all the kind of representative voices. I think probably over the course of the year we heard from somewhere between 40 to 55 witnesses. I don't have the exact number, but each hearing we had between 5 and 10 witnesses. So, our goal was, to your point, to make sure all those distinct viewpoints, those buckets, were heard from. But we didn't just limit it to hearings. In November, for example, Senator Tillis published I think a letter with 15 questions about different aspects of the DMCA that he was interested in this potential discussion draft. And he invited anyone from the public who wanted to submit answers to those questions. Now, obviously, of course, DC trade associations, lobbyists, they all submitted answers, but those weren't the only ones who were given that letter. It was literally, I think, published in Variety. And anyone who wanted to give feedback could. That is very much the process we want to have, is we want, not only the kind of DC world, but the public at large to know you can engage with us. If you have a thoughtful argument to make, we're here to listen.
Oh, okay. See, I love that. And I love that the publication went beyond sort of the traditional channels that trade journals would pay attention to. Variety. That is where, the common person is going to be reading an article and saying, wow, is Congress really thinking about doing this? Maybe I should provide a comment or an answer. So I applaud you on that.
And some
Access.
things were as simple as, please don't do this. I think it's a bad idea. And, that's fine. Almost every single email that someone sent us with a comment, I tried to reply to. Now, obviously, there was a good bit of hate mail too, which I didn't dignify with a response because of some of the language they used. But even if someone sent me an email that just said, I don't like this and here's why, I would try to at least say, thank you. I appreciate you giving input because that's our job, right? I mean, our job is to listen, especially when you have a platform on a committee of specialized subject matter.
So are there any final thoughts you'd like to share about IP policy, the subcommittee, where you think things are heading, what students can do to become more involved?
Yeah, I would just again reemphasize, intellectual property is fascinating not only because of the subject matter, it's wonky, it's academic, it's nerdy, and I use that as a compliment, but it's also it's not partisan. It's somewhere where you as a student really can make a difference. It's where you, Professor Rose is a law professor, can make a difference. And I'll give a great example. Way back in, I think, October of last year, I read an article in Law 360 from two law professors related to issues of patent quality. They had published a law review article where they had argued that USPTO should institute a pilot program that did a couple of things to address patent quality issues. I was fascinated by it. So I then pulled up their law review article, read it, and because of that, I wrote up a letter for the senator to look at. He agreed with it. And the senator sent that to the USPTO, asking them to look at that law review article and institute a pilot program to accomplish the objectives laid out in that article. And so I give that example to say that is kind of the beauty of intellectual property. It is so academic, it is so wonky that even you as a student, if you have a very thoughtful, well laid out argument, make it, because someone will be listening. A lot of the projects I bring to the senator's attention are because I do things like read Law 360 or because I see a law review article published about a certain topic, intellectual property. So it's beautiful in that way. It is truly a chance to influence dialogue and debate and see something actually done if you think it's important enough.
And I am proud to say that Wake students have provided comments in the past, particularly on the DMCA front. So,
and it, just as a testament to Wake students too. So I have a staff of 4 people who work for me on the senator's judiciary team, 2 lawyers, a legislative correspondent, and a detailee from USPTO. And the two lawyers are on my team are both Wake Forest graduates, law school graduates. So you guys are well represented in the Tillis office.
Yes, one of them. I've discussed with one of them the subject matter eligibility debate. And so it is great because they know to reach out to us and they know to test the waters with other academics. So I think it's just fantastic. So before we leave, I do want to open up the floor to see if any of our student guests have any questions.
Great. I love having a dialogue, and please ask anything. I try to be an open book.
Sure, I have a question for you. So earlier you said that certain parts of the pandemic have led to technological advancements, which has made your job more efficient in some ways. Is there anything else that you think will stay around from the COVID pandemic world on the Hill that you think should remain permanent, or any traditions that have sort of faded away that won't be making a return because of that increased efficiency?
Yeah, I mean, so it's a good question. And it's a balancing act, right? Because on the one hand, I do look forward to the days when constituents can come back and again, be in the Capitol complex, can sit on the steps of the Supreme Court, can come to their meetings in our office, because that is a very powerful experience. To get to physically go and lobby your legislators is a fundamental right. At the same time, I also appreciate the fact that by virtue of technology, we can now reach more constituents. I can do more meetings in a day and at different times than I could have pre-pandemic, when I may only have had a 2-hour window to try to meet with 20 different constituents. Clearly, I'm not going to be able to do that. So I would say I hope we take the best of both worlds, right? I hope we get back to a point where those who want to come to DC and meet in person, they can and we're available, but that people don't feel like they have to connect with us. That if they would rather get on a Zoom call at 10 a.m. on a Friday, we can do that. Because at the end of the day, the goal there is to promote access, right? You want people to feel and to have the ability to engage in the process and be heard. And so I think if we take the best of both and move forward with that, we'll be in a good place. Because at the end of the day, that's all it really is about, is making sure constituents have a forum to be heard, to express their views, and to making ourselves accessible for them to do that.
Thank you. And I just have a second question.
Yeah.
I know you're Tom Tillis's, Senator Tom Tillis's personal lawyer, but I guess your client is.
No, I'm not his personal lawyer.
Well, I guess,
no.
Sorry, that's just the question is, people have this framework, this idea that counsel is that person's lawyer. But I guess, can you describe who your clients are, who the senator's clients are, and how that interaction plays out?
Sure. I mean, so I am his chief counsel, which means for things within the judiciary portfolio, I'm kind of his chief policy advisor for those issues. I also am his chief staffer for his subcommittee, which is the intellectual property subcommittee. So in that capacity, I help him, and advise him on, hearings, legislation, nominations. He is my client in this. I think the best way to think about the role of an attorney in the U.S. Senate is it's much like having an advice practice in private practice. Your client is your committee chairman or your senator in their official capacity as a member of Congress, right? So if the senator came to me and said, "Hey, I had a question about this statute. How is it being interpreted? What's going on here? Are there any issues?" I would go and I would research that and I would give him a memo, just like I would in an advice practice. So yes, I mean, I'm his attorney in the sense that, in his official capacity, doing his official duties, my job is to, advise him on the things within my portfolio. But, one thing I always like to remind people too, because I think there's a common misconception that staff have a lot more influence than they do. I always like to tell people, at the end of the day, Tom Tillis has a certificate of election from the people of North Carolina. My job is to give him advice, to answer questions he may have, to present him with the facts and the options. But he is the decider. The people empowered him to make decisions. And I think sometimes there's a misconception about the role of staff, and I think sometimes some staff forget that. But my job isn't to make the decision. My job is to give him all the tools, the equipment, and the advice to make the decision, because you, the voters, empowered him. Brad Watts didn't empower him. You know, I'm not a North Carolina voter, and no one elected me to make decisions. And I think keeping that mindset is critical. Good question. Good question. Others?
Yeah, I had a question kind of about how you end up with a particular senator in a particular subcommittee, knowing that you started out with Senator Sessions in Alabama, then to Grassley, then to Tillis. And I was just wondering, do you kind of early on know that you want to get into the IP field, or did you just kind of get in judiciary and that's just where you ended up?
Yeah, so I mean, some of the first issues I worked on when I was with Sessions were intellectual property issues, and I was always fascinated by them. But you know, the way I came to Senator Tillis, I was working with Senator Grassley, and I was the chief immigration counsel for the full committee. So I was doing all the immigration work for the committee from like 2017 to 2018. And there's a reason I dye my hair black now. Let me just say that there was a lot of gray hair by the end of that process. You know, it was through that work, working with Senator Tillis's office, that I got to know him and his team, and they recruited me when they had a staff opening. So did it all kind of work out? Yes. Was there some type of like grand plan when I started with Senator Sessions, end up with Senator Tillis? No, but I'm glad I did. Tom is probably the best boss I've ever had. And that's it's a hard compliment to give because all the bosses I've had have been really good. Sessions was a great boss. Grassley was a great boss, but you know, Tom beats him out just by a bit. He's a really good boss and treats us very well.
Kind of similar to that question is, what's the next step for you? Like, are you planning to be, I don't know if this is a question that you can answer if you know the answer to it, but kind of like, what's the general trajectory from here? Are you going to stay where you are for the next 10 years, or what do you think?
It's a good question, and I'm not entirely sure. You know, I love my job. I love working for Tom. He's a great boss. I love my team. I love my office, and the work I get to do really is fascinating and fun. That said, and this is, again, me just speaking personally and I guess pro advice for some of you young lawyers, I think it's always critically important to keep challenging yourself, giving yourself new opportunities, forcing yourself to grow and to learn and to be exposed to different situations. And any job, no matter what it is, you know, you get to a point where you may run the risk of stagnation, not because the job isn't rewarding or isn't fun or the issues aren't challenging, but you know, think about being a district attorney. You know, you're going to get to a point where, yes, you may have one murder case every few years or one very high profile criminal case that is truly challenging, you know, but the bulk of your work is going to be kind of some routine things. Think DUIs, think, you know, minor assaults, minor felonies. And just like anything else, it may no longer be challenging you, even though the workload is, you know, incredibly heavy, even though you've got a lot to do and you're good at it. It may not be the type of challenge that it was 10 years ago. And it's the same thing working on the Hill. The Hill's no different, right? I mean, you know, you get to a point where you have to continue to be challenged. And so I think personally for me, you know, in the next few years, I may move off the Hill to do new things. And again, that's not because I have a bad boss or a bad job. Love my boss, love my job. I could stay in this position until I retire. That's how good it is. It's just, again, for all of you, as you look ahead to your careers, never lose sight of the fact it's important to keep challenging yourself. Now I feel like an old man for saying that.
No, and kind
A
of
wise man, not an old man.
yes, and following up on that question a little bit, just is there anything, knowing the job you have now and being a legislative counsel and working for a senator, is there anything you would have done differently in, say, law school or your early career, or something you would have focused on, or a recommendation you could give to other students or young lawyers in our position?
Yeah, I mean, it's a good question. And I know the answer I'm about to give is going to make me sound so arrogant or out of touch, but just bear with me, I'll explain. The answer is no, there's not really a ton I would have done different. And the reason is, and again, give me a chance to explain before you scoff and you're like, oh, what is he talking about? But the reason is when I went to law school, I didn't actually think I would end up in DC. So when I was in law school, I gave myself a lot of different experiences. I worked for a prosecutor's office one summer. I worked for a civil litigation firm. I was a research assistant. I took civil law classes. I took criminal law classes. I took business orgs and secured transactions. I kind of wanted to give myself a general experience. Being the first lawyer in my family, I didn't know what I wanted to do. And so I came up to DC actually, and I thought it was only going to be for 1 year. One of my roommates is actually in here in the kitchen cooking right now. He and I moved up here together, and I think we both thought we would only be here like a year. That was the commitment I gave to work for Senator Sessions' judiciary staff. 1 year, that's it. I'm going home to Alabama. So, here I am 6 years later. So I don't know if I'd have done anything different, mostly because I didn't necessarily see myself here. Glad I'm here. I love the work, but I kind of built my law school career around, I think, this idea that I was going to be back in Alabama practicing in a small to medium-sized firm. Now, that said, for those of you who are thinking about working in the government, whether it's a federal agency or Capitol Hill, again, going back to what I said earlier, Congress is very much like a guild in the sense that you need to have experiences, you need to have a network. And so if that is something you're wanting to do, I would encourage all of you to come up and clerk or intern, get some substantive experience, build that network. That'll be what opens the door for you. And to the extent our office can ever facilitate a clerkship, happy to explore that with you. Obviously, that is a byproduct of things like space and constraint. But, if we have opportunities, please reach out to us. And even if we don't, I'm happy to help you find opportunities, because those really are going to be what gives you those jobs. I mean, again, I didn't get my job with Sessions out of law school because I was like best person to ever come through the University of Alabama School of Law. It was, I had worked with him. They knew my character. They knew my work product. They knew that when they hired me, what they were getting. It wasn't a risk.
Well, with that, sir, I'm going to be pausing on your time, and so we thank you for your participation here today. If there aren't any further questions, go ahead and close us out.
Well,
okay.
No, Professor. I was just going to thank all of you for having me and inviting me. I really enjoyed this dialogue. And I just want to emphasize not only to all of you, but your viewers, I've got an open door. If a student or faculty member or someone in the intellectual property community reaches out and wants to get in touch with me, feel free to give them my email. I'm happy to be a resource professionally and personally. And especially for the students, I want all of you to succeed. I've been in your shoes. All of us who have been in your shoes know how stressful it is. So, please feel like I am an ally and an advocate for you, and you can reach out to me.
And I was going to thank you for being so very candid and giving such sage advice to our students. I know a lot will be interested. I agree totally with you about don't think of law school as a track. Think of law school as an opportunity to learn about a host of different things. I entered law school thinking I was going to be either real estate or banking attorney, despite the fact that I was an engineer. And so I ended up finding that I really did like this intellectual property thing, because you could do more than just patent law. So it's just wonderful that you've taken the time to talk with us and be part of our symposium.
And if I can just make one more comment too, and you really hit the nail on the head, and you're going to love this as a secured transactions professor. But I was just talking to someone a couple of weeks ago about secured transactions and how glad I was I had taken it in law school. And they're like, well, why? You don't do anything financial services related. Like, you're probably not going to be like a credit litigator or anything. Like, so why are you glad? I said, because the way it made me think about issues in terms of the pipeline is something I still use to this day. Patting myself on the back a little, one of my few good skill sets is that I'm very good at time and project management. And part of why is because I incorporated that thinking from secured transactions into how I think about projects, i.e. it is a pipeline, and you got to know when in the pipeline to bring in something new and remove something off the pipeline. And so, to your point, it's a testament to the fact of, don't just look at law school or the classes you take as, oh, I just want to learn this substantive subject. Yes, do that, but also try to think about, well, how is this subject teaching me to act and interact with the world at large? That, to me, is some of the real value.
Couldn't close with better words. Off to you, Maurice.
Again, thank you, Mr. Brad Watts, for your time today. Thank you, Professor Simone Rose, for your participation with us today. And as we said earlier, The interaction between communities is one thing we study here at Wake Forest, and we thank you for being a part of our community, and we hope you stay connected. Thank you.
Thank you, guys.